Yes. Item number 3. Okay. Pass for the day as prayed for by Mr. A.R. Sigdal and counsel for the petitioner. You say both sides are present, huh? Okay. In fact, today we are glad you have some problem. No, it's okay. I'm saying in a lighter note because 1 or 2 days there are some disruptions. We have, so that's why. No, now there's a difficulty because there is a notification by Honorable the Chief Justice that one of the matters I can't take up, that is item number 13. It has to be not before me. No, but we understand, but it's a batch matter. We can't segregate and take it up. In this, we understand, but now we have in the difficult situation. Item 12 to 16 pass a common order, but after it is checked, give copies of that order in all the record. All sides, including Mr. H.R. Chaudhary and his senior counsel for the applicant in IA Criminal 307 of 2024 are present. Next para. In this series of matters, in view of notification number 49 dated 27/6/2025, the proceedings of criminal appeal 258 of 2023 cannot be taken up by this bench. By one of us in this bench, within bracket K.R. Surana J. Accordingly, the registrar shall list the matter before any other bench without one of us, within bracket K.R. Surana J. Next para. Mr. H.R. Chaudhary and senior counsel expresses some urgency in his interlocutory application full stop. His assisting counsel is permitted to move the registry for urgent listing. Okay, we have given you that. You can write a letter. So just also add her name, Mrs. S.H. Boran and APP. All, including so-and-so and so-and-so are present. Okay. Item number 2. Twenty-fourth, there is a special bench. It will go to 29th. According to your assessment, how much time will it take? No, but no. That thing is very dangerous. I've almost become a master of parted. Just I don't have the degree. No, but he has the Advocate General of Nagaland, sorry, Arunachal has some difficulty. No, 25th is a motion day. 25th, this bench is taking up foreigners' matters. That's why we are asking an assessment of time. काम कोई पाने की यहाँ पे क्विटिंग पीरियड is taking a long time. Then they will make a restrictive argument and give their notes. Notes होता है हमारे जल्दी क्या तुम भाग एक में subject in that case, uh, all of you, are, including Mr. Ahmed, is here. If it is taking a lot of time for the argument, then what I propose is that whenever we fix the matter with consensus of all of you, in advance you give us a written note of submissions and do it, and therefore we can restrain the arguing time and then we deal with the issue because because in this current scenario, keeping a things parted is very difficult because we don't know the from maybe perhaps the bench may not be maybe changed or something. We don't know about it. So we are in a till this week we are not in a very clear position. So can I say that written notes in advance? Now we agree to a date, all of you. 5th. Okay. Uh, okay. Just give a slip of paper. Mr. Gautam, please write the names of everyone so we don't. Give names also, Mr. Datta. So and so. Appearing for the parties are present. Next para. Mr. N. Gautam, learned counsel for the private respondent. Respondent number 6. Praise for adjournment. Post of prayer is considered and allowed. After some discussion, the learned senior counsel and learned counsel for the respective parties have arrived at a consensus that the matter be taken up on 5th, 5/8/2025. Next para. It appears from these submissions made from all appearing parties that the hearing is likely to take some time. So accordingly, the court proposes that before commencement of the submissions from all sides, a written note of submissions be provided in advance so that the arguing time can be reduced. Next para. List on 5/8/2025. Can I add that on that day no adjournment? Do you want that to be recorded? No, you see, two things can't go together. Number one, convenience, and number two, fixed date. These two things can't go together. No, not written argument, but if you start, because you see, everybody comes prepared. And I knowing Mr. Ahmed, Mr. Chaudhary, even you, I think you will start preparation 1 or 2 days ahead. So that's why I'm asking you, because then we are also prepared. Unless you don't want us to be prepared. Unless you don't want us to be prepared. No, that's true. That's why we are asking you time and again, because you have a very important role to play.
Your Lordship may not make that observation, but the understanding is that we will come prepared.
Okay. And things are happening. There's the word in the pipeline. Things are happening. No, that's okay, but this event will be happening.
Yeah.
It's for sure. Okay. We'll have clarity by evening today. Okay.
Right.
Mr. Ahmed, I'm looking at you with a stick. Is it everything is okay? I did not notice. Even I'm sorry, I forgot. Even if I have noticed, I forgot. So everything is okay. Health is okay. Yes. Item number 17. Okay. 2 weeks. 17. Okay. Give it. We don't know. There'll have to be some adjustments. This week is very difficult.
Supplementary list, item 21 for motion.
Now, pursuant to the
This is a WT message. That's appears there.
just a moment. No, but then you did not take bail in terms of the order.
Yes, in this person to this minor, they take bail, he takes bail and COT, personal bond minor. And personal bond.
No. As per the instructions produced, you have not appeared and taken bail pursuant to the order in the repression.
27/9/2021.
You have not taken bail. That's the specific instructions.
It's not sorry, I have not communicated this.
Oh.
They are not aware of this. Because at the delivered time, by Lord's communication was.
Then you'll have to file an IA in that application. This repression has to be closed, and for extension of bail, we can't do it in criminal petition, writ petition. You'll have to file an interlocutory application in that WBC.
Bail is, she's in bail, Lordship. She still she's appearing.
No, that can't be. There's an order of bail, but you did not take bail. The difficulty is there. You'll have to seek extension of time to appear and take bail. Your COVID bail will not give you coverage of the benefit of orders passed in WBC 46 of 2018.
If they Lordship may allow the husband, the petitioner to meet his wife.
No, we'll permit that. What we'll say is that we give you visitation right. You take your wakalatnama from there and then you file this application
In that 46.
in 46. Okay. We allow.
In that case, I was engaged by legal aid, my son.
No, whatever be, we are not questioning what has happened, but
There, my Okalana is there, I think so.
Now she's in the holding center, Lordship.
okay, you want the affidavit of the application to be sworn by someone else.
Yes.
You do it, that's not a problem.
Husband,
For that, you don't require an order. You can always present. We keep it pending for some time then. this matter?
Only prior to meet.
Visitation right, okay. Heard Mrs. P. Burman, and counsel for the petitioner. Also heard all the responses of Mr. M.R. Adhikari, SCEC, and Mr. Cooley for on behalf of Mr. A. Ali. Next, pursuant to order dated 19/7/2025, or the Mr. G. Sharma, the next standing counsel for the FT and border matters, has produced a copy of written instructions dated 21/7/2025, received from the Senior Superintendent of Police within bracket B border. It is border. Kamrup Amingao, that pursuant to order dated 27/9/2021, passed in WPC 46 of 2018, Asia Khatun, alias Achia, ACHIEYA, you'll find it in para 2 of the last order, was a proceedee in GFT within bracket R, bracket close, case number 200 of 2017, arising out of IMDT case number 734 of 2002, decided by opinion dated 18/9/2017, passed by the learned member, Foreigners Tribunal number 1, Kamrup Rural Uluwari, Kamrup Rural, don't say Uluwari, was granted bail by order dated 27/9/2021, passed in WBC 46 of 2018, did not apprise the border police regarding challenge to the FT order by filing a said writ petition, and she had not appeared before the Office of Senior Superintendent of Police within bracket border, bracket was Kamrup, in compliance of the order dated 27/9/2021, passed in WPC 46 of 2018. Stop. It has further been informed that the said declared foreign national is currently lodged at the holding center, Kokrajhar, i.e. holding center at 7th AP Battalion, correct?
Yes, Lord.
Saraikhola, Kokrajhar. Next, brother. Be that as it may, in view of the disclosure of the place where the said declared foreign national is lodged, the court is inclined to grant the petitioner, namely Mohammad Akbar AKBBAR, Akbar Ali, liberty to visit and meet Asia Khatun, alias Achia Khatun, his wife, at the holding center, 7th AP Battalion, Saraikhola, Kokrajhar, along with one family member. To meet the said detained person.
Right.
Problem.
Next, brother. As prayed for by the counsel for the petitioner, it is made clear that the pendency of this writ petition shall not be a bar for the said detained foreign national to move this court for extension of bail in the connected in the WP in WPC number 46/2018. Next paragraph. The learned the petitioner shall produce a certified copy of the order before the in charge of the holding center, 7th AP Battalion, Saraikula, Kokrajhar, so that the said authority can arrange for the visitation right of the petitioner and one family member. Next paragraph, list on. We listed after a week.
After 2 weeks, my lord, in
307/2025.
I have to file the bail.
We have given you liberty. We are keeping it pending so that you can go and visit and tell us, then we'll close it. We have given you liberty that pendency of this will not be a bar for you to seek extension of time.
Supply item 22 for motion.
May I please, my lord? In this case, my lord, one IA and affidavit has been filed on behalf of BSF, but that has been done on Sunday. So it is highly unlikely that both this petition has come before the.
Okay, what is your stand? Please tell us.
No, my lord, he has been pushed back to Bangladesh border, and that has been reflected in our affidavit on behalf of BSF, my lord.
Okay. Your affidavit is here, don't worry.
My affidavit is there,
Yes, yes.
but my lord, I do not have the copy because the clerk hasn't come till now.
We have a robust system working here, that means.
Then I prayed my
Just a moment.
deeply of this. Huh? I too attend you. Oh.
You have received copy of that?
Yes.
We find these on the election.
We adjourn the matter to enable you to get instructions what to do because it's been pushed back. It's just recording the order. Ms. G. Boral and counsel for the petitioner. Also heard all the respondents there, Mr. B. Decker, counsel for the CGC for the respondent number 1. Next paragraph. Pursuant to order dated 19/7/2025. And affidavit has been filed by the Border Security Force. No, 18/6/2025. 18/6. That to the effect that
To make it say the loop. E to 2
at the request of Assam Police, 109 numbers of declared foreign nationals were collected by what is the DC of DC means?
My lord, the deputy commissioner.
No,
District Commission.
Huh?
paragraph 3 of the affidavit.
Oh, let me see, my lord.
DC means-
I'm not familiar with the deputy commandant, my lord.
The deputy commandant
of
of 66
Battalion.
Battalion
Battalion.
BSF from the transit camp Matia Gwalpara on 26/5/2025, and the name of Idrish, IDRISH, Ali, is mentioned at serial number 72 of the list provided by the Assam Police, which was handed over to the, and AC means Assistant Commandant. to the Assistant Commander of 89 Battalion, BSF. No, not that. Full stop. Out of 109 declared foreign nationals, 36 numbers of so 36 declared foreign nationals were handed over to the Assistant Commandant of 89 Battalion, BSF, and the remaining 73 numbers of declared foreign nationals were handed over to the officer of sector headquarter, BSF, Kuch Bihar, and that said Idrish Ali, along with 35 other declared foreign nationals, were pushed back to Bangladesh side from the AOR. What is AOR?
My lord, I am not familiar.
Area operating region.
Area
Area
operating
operating
region. Okay. Area operating region within bracket AOR of ad hoc capital GW 2503 Battalion, BSF, under sector headquarter BSF, Dhubri within bracket Assam on 27/5/2025. Next paragraph. Accordingly, on the prayer made by Land Council for the petitioner, the matter is adjourned to enable her to obtain instructions. Next paragraph, list on 307/2025.
Deep privilege, my lord.
Mr. Adhikari, I had a very short memory. Please tell us that AOR again.
Area operating region, Madam. This is what I was told on the last occasion when I had appeared for the VSF matter, Madam.
Area operating
Region,
region.
Madam. That's what I remember. This is what I was
No,
told.
that's okay. I have a short memory, so if
Well-
I prefer asking so that
Madam.
this is very clear.
Madam.
Because I normally dislike writing abbreviations in the order.
Yes.
At times, if I don't know what I'm writing, it looks very bad. So I try to give the full.
Yes. And in these communications, Madam, the BSF and CRPF and all, Madam,
No,
they
I
all-
understand. It is normal for them, but so far as I am concerned, I try to make my orders very clear
Madam.
so that normal man reading this order cannot
Yes.
cannot be left to any chance of what this means.
Madam.
That's why only nothing more.
Obliged.
Yes, item 1.
I want to go through the TCR ones. Through the TCR, the record one.
Okay, go through it.
And for the time being, after something.
Jamaluddin Asina na Jamaluddin. Item 4. দুটা এটা অ্যাডভোকেট হলে মানুষ আসেনি পিছপা 7 লজিক্যাল record follow প্রবান and for this one without record go to সাব বিষয়ে বলুন এটা
Item 4.
So complete the petition.
না রে ফটো বাইশ আগে সিধা No, diluted to myself.
Recorded in both, total is 1970, page 11 minor.
Minor things. For the time being, I want.
Okay.
Let him argue, let's see argue.
Thank you.
I,
Well,
Ms.
actually,
Rajita, can I request you to shout?
My lord,
I can't hear you.
my lord, petitioner's father's name.
It's okay.
Just put
Just a moment.
the page 11,
Yes.
page 11, my lord.
Huh?
No, it is there. Hold on, I don't know.
Just increase it. You have to strain to hear you. You come a bit closer so that you don't miss your good argument. Yes,
My lord, page 11, my lord.
page 11.
Petitioner's father's, my lord, petitioner's mother's name, my lord. Both names.
Just a moment. Just a moment. Page 11.
My lord.
name to me at the house. Paper like eligible. Money.
Your Lordship,
Please.
I'm sorry, Your Lordship, that AOR stands for area of responsibility.
Area of responsibility.
Yes,
Okay,
yes.
okay. Thank you.
I'm sorry,
No, it's okay. Thank you still.
yes.
Area
I
of-
got it confirmed from them.
No, it's okay. Area of responsibility.
Yes.
Okay. But thank you still. Yes, yes, this Joharuddin is your father. Okay.
Father's name.
Yes,
The total is, my lord, 1970, my lord. Thereafter, my lord, I have annex 1985 voter list, page 13, my lord. Petitioner's name recorded, my lord.
page,
Page 13, one thing.
but please come to your written statement. Is it annexed here? No. In the written statement, please see, I think I missed the change of village. Because the father's voter list is at village Sahoria Palm. And this page. No, the father's is at, no, that is Udhan Tola. Page 12 is Udhan Tola.
Nothing has been mentioned, Lordship.
Page 14, this village is Gaon Sahoria Palm. No, I don't know.
Nothing has been mentioned in the written statement.
It's not there.
Thereafter, reorganization of this district and police stations, my lord. Thereafter, petitioner jurisdiction is, my lord, Lahorigarh police station under Morigaon district, my lord.
Police station is Lahorigarh on in both the villages. Sahoria Palm as well as Udhan Tola.
Villages.
The police station is Lahorigarh. But if this is the only document you have, then you will not be able to connect yourself to your projected parents. And I think in your written statement, you have also not given your family.
No, no lordship.
This you you have exhibited the certificate by this Gram Panchayat. Did he come and depose?
No. No lord.
That is not the, if I remember correctly, Mr. Sharma, please check in the written statement.
Yes, lordship.
The written statement also does not explain the change of name of
No.
father.
No, nothing has
It's
been
not there.
mentioned, lord. Nothing has been mentioned. Hmm. May I read Lordship para 8 of the written statement? Lordship, regarding shifting, yes, Lordship in vernacular, I am reading Lordship.
Yes, yes.
দ্বিতীয় পক্ষৰ পিতৃ মাতৃ পৰৱৰ্তী সময়ত অসম বিধানসভা 83 নং ধীন নতুনৰ অন্তৰ্গত মৈৰাবাৰী চহৰীয়াপাম গাঁৱত আহি বসবাস কৰি থাকি দ্বিতীয় পক্ষ আন সদস্যগণক এই সংসাৰত থৈ মৃত্যুবৰণ কৰে। দ্বিতীয় পক্ষৰ নাম চহৰীয়াপাম গাঁৱত ভোটাৰ তালিকাত অন্তৰ্ভুক্ত হৈ আছে যদিও কেইবাবাৰো বিভিন্ন নিৰ্বাচনত ভোটগ্ৰহণ প্ৰদান কৰিছিল যদিও ডি হিচাপে চিহ্নিত হোৱাৰ পিছৰ পৰা ভোটদান কৰিব পৰা নাই। That much only written Lordship. Otherwise, when they have shifted Lordship on under what circumstances they have to shift Lordship, that was not mentioned. And regarding change of name Lordship, there is nothing has been mentioned Lordship in the written statement Lordship.
Yes.
My lord, petitioners, in this voter list, my lord, his name is only D mark is my lord. Not a suspected as a foreigner, my lord. Marking is a D.
Please repeat again. I did not get it.
Voter list, my lord, his name is only marking is a D, my lord.
That means you are thoughtful.
1970 voter list is of his father. And 85 is his name. And in the voters list of 1985, he appears to be of 31 years of age. Therefore, he has full 10 years. That means his name should have been there in two voters lists in between.
Yes.
Your case is that you after marriage you came to this Sohria Palm and started living there. But you've neither given the time when you were married. And when you left your parental home and came to live in the second village, and you don't even disclose where you were residing. In the evidence, you have stated that you are residing somewhere and doing work. Please read that evidence.
No. DW1 Zohuruddin.
Just a moment. Yes.
মই অপৰপক্ষ হওঁ মোৰ জন্ম উধানতলাত হৈছিল ৰূপহী থানাৰ অন্তৰ্গত চহৰীয়াপামত বিয়া কৰাও তাতে থাকো মই ভোট দি আছো ম-
মই ভোট দি আছো।
উম, উম, এইটো কি হৈছে something is এইটো কৈছে মই হে Okay. মই বিদেশী নহয় then lordship in cross part
Here he says he's living in somebody's land.
yes
When I could then.
Please pass it on. He said somewhere that he has no land. He works.
yes
নিজৰ ঘৰ মাটি নাই।
yes
Second and the cross examination.
Okay.
এইটো But the handwriting is very bad.
lordship
এইটো
writer should be a doctor writer should be a doctor lordship
reasonable expectation. But then sorry, Miss Vedha, there's no connect. If there's nothing in the evidence on then the readings. And then when he admits that he was a voter, there's no point to not to produce the voters list. He says in the cross-examination that he was a voter. Mr. Sharma,
lordship
where did he say that he's a voter? Is it in Chief?
voter no lordship what's that this is Yes, Lordship, মোৰ অপৰপক্ষ মোৰ জন্ম উঠানতলীত হৈছিল
In chief,
দুই থানাৰ
in chief.
অন্তৰ্গত তাতে থাকো মই ভোট দি আছো Yes, Lordship, in chief.
But Mr. Kudi, please come to this page 14 of the writ petition. Page 14, this is the first voter list of the petitioner which is he has annexed.
Yes.
And as per the case of the petitioner, he was declared to be a D voter in this 1985. But in this certified copy, there is no D.
No. He has come from Lordship from the year 1997 Lordship. And when he was marked as the Lordship, since then Lordship, his name was not reflected in the voter list Lordship. She is claiming like
Is in
that.
which voter list?
So I think Lordship, this is in the year of 85 Lordship, this voter list relied on. But after that Lordship, nothing.
No, but the case of the petitioner is that he was a D voter.
Yes, Lordship, but that voter list was not annexed Lordship.
That is not produced.
Lordship, I think Lordship, this is somehow OCD has collected this voter list Lordship and this before the tribunal Lordship.
Oh, in 97.
Yes, Lordship.
Okay. Mr. Sharma, please pass on that because I think I missed this exhibit Cho.
No.
Dark Chitar. What does it say? Exhibit Cho? George, Cho, I think, CHH. Cho. Dark Chitar is there, exhibited document. Please see that.
This is a Posim Romari Lordship. Moja Ali Tangoni. Village name Lordship. Lordship. D. This log চিঠা this জমাবন্দী
It's a draft cheetah. The top you find draft cheetah.
this জমাবন্দী lordship
Jamabandi.
exhibits
Okay. Please pass it on.
original to আছে নাকি
No. This exhibit show is a document I did not read it earlier, but this completely damages your case. You don't inherit the land of your father. There are three persons who have inherited the land. Soharuddin, Samsuddin, Samiruddin. There are three persons who are inherited the property of your father. Okay, we close the matter then. You have anything more to say? Okay. Heard Ms. Al Wazida, land counsel for the petitioner. Also heard all the respondents of the so argument is concluded, judgment is out.
Time being at
Yes, want to say something?
Item 5, my lord, I'm praying for adjournment, my lord.
Item number 5.
My lord.
Okay, make it after 2 weeks. Okay,
Like,
time being item 1.
yes.
No.
You have seen the record?
Lordship, earlier I have seen, today I have not seen Lordship.
It will. I mean, you should. Yes,
My lord, the 1965 is the father of page number 48.
page number
48, my lord,
48.
48. Jaminuddin. And Lord, next 1970 for the name. This is my lord village Samdhora. This is on the Nagaon, in the Nagaon district, my lord. The 2 and 3, my lord. My lord. So, my lord, after this, the petitioner in 1975, he shifted to Golaghat district, which is mentioned in page 94 of the TCR. I don't know, I have not annexed the WS, so I do not. But the WS there in the TCR, it's page 94. My learned friend can verify. Page 94. And he bought a piece of land, my lord, which is annexure 4, page number 52. There is another plot of land, my lord, which is page number 58, my lord. This is 1993. Page number 67 is the voter list of the petitioner, my lord. There is a little variation in the name, Jamiruddin actually, Jamirat Din.
Page number?
67.
এটা ভুল করে বলতো স্পিকার টু
Sorry.
স্পিকার টু ভুল করে
Oh.
Page number 67 is the 1997 voter list, which is Annexure 6 also was Exhibit 6 before the learned traveler.
This voters list of 1965 is which village?
This is my lord in Tamdhara. It is in Nagaon district under Rupuihat PS. Actually, Samdhara is in Samdhara.
And this 1970,
1970, same village, Samdhara.
this does not contain your name.
No.
This
He
is,
was born in 1959. my
no,
lord.
whatever, this is voters list of your father, projected father.
Father.
Is your father alone or the family members are there?
In the 1965 mother name is there. The 1970 mother name is not there. It's just a standalone. When certified copies are applied, generally my lord, 1% or 2% name it is.
This exhibit 4 is the sale deed.
Sale date.
Which village?
This is my lord. Exhibit 4 is. It's ward number 1, Golaghat town. 1984.
This is 89, I believe.
Next page, my lord, 53, 15th day of March 1984.
Page number
84, my friend can check it.
54,
15/3, 1984.
84, my lord.
84. Yes.
1984 means 1890. 84.
Uh,
64 sound district. 54. 60.
64. Twenty-three, 793. Itu password pieces.
Annexure 5 is 1983, so sale date.
This exhibit,
My lord,
exhibit 5 sale deed is of which place?
exhibit 5 is sale deed of my lord. Is same place, my lord. Ward number 1, Marwari Patti. Golaghat. 4 and 5 from same place, no? Both the failed it.
Voter list of 97 is which village?
Voter, Milord, page number 67 is Salmora 2. Same district, Milord, but in a different moja. Subdivision is Dhansri.
Salmara 2.
Salmora 2, TUP. Exhibit 6 in the record.
Yes.
Same village, Milord, next annexure, which is also exhibit, which is exhibit 7. Hazrat Ali, the father name is written here. Same village, Salmara 2. This is 2005 voter list, Milord.
This is which village?
As same as 1997, Salmara 2 in Golaghat district.
The evidence was led by DW1, who is the petitioner.
Milord.
Evidence is given by DW1 is petitioner.
My lord, I have not annexed it because I was.
No, it's okay. But
Yes,
DW1 is the
who's
petitioner.
Petitioner,
Who is DW2?
DW2, my lord,
School
is the author of school certificate. Annexure. First, I would like to take your lordship because this is the most important document. Page number 74, my lord. Then I'll take your lordship to page number through DW2. My lord, page 74.
Yes.
This was, my lord, exhibit 9, my lord. This is the school certificate, my lord. And this is from the village, Samdara. 1966 and 65 and 70 voter list, my lord. This is the most important link document, my lord. Now, my lord, I would like to take your lordship to next page, which is DW2, my lord. DW2 is the present principal of this school, Juria High Secondary School, my lord. The next page, 75. May I read, my lord?
Yes.
My lord, I am the principal of Juria High Secondary School. I was working as the principal of the above mentioned high school since 2022. I am working actually. I have submitted exhibit 9 along with the document of the previous school, Tetelia Pathar Maktab School, where Mr. Hazrat Ali, son of Muhammad Zamiruddin, resident of village Samdhara, has studied. Is added as exhibit 9 1. It is there in the TCR, my lord. 9-1 is in the page 145. My learned friend can go through it. Page 145 is 9-1, which is the earlier school certificate. The original copy of the exhibit 1 and the admission register for a school of the year 1969 and the counterfoil of the exhibit 9 is submitted by me before the learned tribunal. I think this is page number 84, my lord. The admission register of 1969, my lord. Page number 89, my learned friend might check, me now. Where it is clearly written, my lord, that he was a student of that school. As per the admission register of 1969 submitted by me, the name of Hazrat Ali, son of Jamiruddin, resident of Samdhara, is mentioned in serial number of the admission register. As per the admission register column 12, the date of birth of the above mentioned person is mentioned as 1/10/1955, and in column 13 and 14 and 15, the age of the student as per admission in our school on 23/1/1969 was 22 years, 9 months, 3 months, 9 days. Probably, Lord, there is some mismatch here. It cannot be 22, Lord.
And this next statement which is coming
My lord.
reminded me of nursery rhyme which I read in class perhaps 1. After more than 50 years, I have remembered that nursery rhyme again. It starts 30 days in September, April, June, and November. Rest of the months are 31. There's a nursery rhyme I read when I was in class 1. Yes,
Yes.
remember it. Now here the next line, the man says, according to me, it is wrong. The student's birth date is 31/9/1959. So he has 31 days in September.
It is what it is, my lord.
I don't know. But thank you for reminding me my nursery days.
My lord, may I complete, my lord?
Yes.
We have the above mentioned student.
No, but if his evidence is against the document,
Hmm.
everything goes.
My lord, why? Because the principal who issued the certificate is DW3. There is a mismatch because your lordship can go through the record. Now there are two things, my lord. What I want to prove from this document. One is that there is an admission register of 1969, and there the father name is written. And both the existing principal and the earlier principal deposed and said that and submitted the earlier record and said that this is his sign. So there is a clear, of course, my lord, I completely agree with your lordship, and whatever there is in record is on record, my lord. But it proves that he was a student of this school in 1969. That is my sole point. That is my sole point.
There is a slight difference in father's name.
Yes, it's Zamiruddin
Jamiruddin
and
here-
Zamiriaddin. There is a slight difference. There is a slight difference. There is a shifting also 1975. So these are a matter of record.
DW three below, maybe below one, DW two below.
Lordship, for the impugn order, the reasoning why document was. There's a long discussion in the impugn order.
The operative part, the evidence records 31 gap. So therefore, it can be September, it can be October. Therefore, these two authorities are inconsistent in their evidence. The author is DW two or three.
Three.
DW three is the,
Author is three. Author is three. It does not take away the moot point Milad, about the originality of the and the authenticity of the certificate. So on this point, both the DWs were not cross-examined, That it goes against Nahar Singh, Shwini Kalita also.
okay.
May I take your lordship for the impugn order?
You said DW, who is the author of the document?
DW3.
DW three. Yes.
So DW3 has the signature of the seal of the principal exhibit belongs to me. The signature and seal of the school is mentioned exhibit 9. So he has verified the document. And-
You are reading from where?
My lord, page number 8. I will take you your lordship to page number 79.
79.
79. The entire deposition I would like to read.
What is the name of DW two?
DW2 is my lord
Rupalim Pharma. Miss
Hmm?
Miss Rupalim Pharma.
Rupalin Sharma.
DW two.
Yes.
DW2 is Rupalin Sharma.
And DW3 is Prasanna Kumar Kulita.
Lupali Sharma SARMA.
Yes. SHERM.
And DW three is?
Prasanna Kumar Kalita.
Come back.
My lord.
In one aspect, just because my esteemed sister could read it properly, we are not asking you a question because your typing is erroneous. You would have, had my esteemed sister not seen it, you would have dismissed your petition in limine. You know why? Come to evidence of PW2 at page 76. Second last paragraph. Last two lines. In exhibit 9, the signature of principal of the sign of the previous principal, Sri Pranayan Kumar Kalita. Correct? You're saved just because of my esteemed sister. Come to page 78. Second last line. Of the second last paragraph. Agor Adhyakya Sri Prahanna Kumar Kalita. And then come to this page 79. Again, this is some spelling error, but it should be Prasanna.
But Zamir is written as Zabir here. It is, in the original it is written as Zamir. I'm grateful to your share. Saved my trip.
My esteemed sister would have saved you because
My lord.
I would not have read the English translation, then the Assamese, and then found out. Next time, be cautious when you are making a translation.
Fine.
Take a break and come back.
My lord.
মই যোৱাৰ পাছত মই যাওঁতে চাৰি চলি আছে আইটেম অন টাইমিং হৈছিল এতিয়া চলি আছে এতিয়া মানে 1 পাছত মই 6 মাতিম ন 6 মাতিব 6 ফাইলটো ওপৰত আছে এতিয়া CAV-টো অকণমান ৰ'বচোন এতিয়া CAV-টো মানে কি এই আইটেম 5 আইটেম 4 ৱাজিদাই মানে কি ৱাজিদাই হেৰি কৰিছে তাৰমানে এইটো ৱাজিদাই এটা এপিয়াৰ হৈছে আৰু এইকেইটা উকিল ইয়াত CAV-টো ডিক্টেশ্যন এটা হয় নহয় এইটো শুনে অলপ চম্পকে লৈছিল চম্পক হয় ন চম্পকে উকিলৰ নাম লিখি থৈ যাব ঠিক আছে এটা কাম কৰিলো ন তোমালোকৰ জেঠাইহঁত আজিকালি ক'ত থাকে আগতে যেতিয়া চাকৰি কৰিছিলে ওচৰতে ক'ৰবাত ভাড়া আছিলে ৰেণ্টত আছিল ন দুইজন ৰিটায়াৰ হোৱাৰ পাছতহে বেলতলা গৈছে নেকি তোমাৰ 12তে গৈছে ন বহুত দিন হ'ল তাত মাটি কিনি ঘৰ বনাইছা তোমালোকৰ জেঠুজনৰ ঘৰ ক'ত হয় নেকি ঠিকেই ঠিকেই হয় হয় তেখেতৰ নামটো কি দাস আছিলে মই পাহৰি গৈছো তোমাৰ জেঠু হে হে নিৰ্মল দাস নে আগতে কথা চথাও পাতিছো মানে নামটো মুখত অহা নাই বহুত দিন হ'ল 6-7 বছৰ হ'ল নেকি। ল'ৰাটো ডাঙৰ হ'ল চাগে ন এতিয়া তোমাতকে সৰু নে সি তোমাতকেও ডাঙৰ ন সি মানে তাক 6-7ত পঢ়ি থাকোতে দেখিছিলো আৰু সি কি কৰে এতিয়া B.Ed কৰি আছে B.Ed কৰিছে কিন্তু জব পাব B.Ed ভাল অ হয় হয় আৰু ভালকে পঢ়িলে স্কুল ইন্সপেক্টৰ বা এইবিলাকতো কৰিব পাৰে B.Ed বেয়া নহয় মোৰ ভতিজা ল'ৰাটো কৰিব দিছিলো মানে মোৰ হৈছে সি ইমান এটা ইণ্টাৰেষ্টেড নহয় থাকিব লাগিব ঠিকেই সি আজিকালি পঢ়াত আগ্ৰহ আছে কিন্তু সি কৈছে না মই টিচাৰ নহওঁ এই তেনেকুৱা মানুহৰ ইণ্টাৰেষ্ট থাকিলে ভাল মই তাক B.Ed কৰিব কৈছিলো মানে সেইকাৰণে কথাটো কৈছো আৰু তই B.Ed কৰ কিছুমানে ভাল পায় হয় 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 তোমালোকৰ দেউতা আচল ঘৰ ক'ত এতিয়া য'ত থাকা তাতেই নে বেলেগ ক'ৰবাত আছিল এতিয়া ইয়াত দেউতাই নিজে কিনিলে আৰু তেতিয়া তোমালোকৰ ককা দেউতাই কিনা নে দেউতাই কিনে হয় হয় নেকি তোমালোকৰ ককা দেউতা মানে এইটো ঘৰত থাকি গৈছে মানে ককা দেউতা এতিয়া জীৱিত নাই হয় বুজিছো বুজিছো তুমি পাইছা আৰু মানে হয় তোমালোকৰ দেউতা ককাই ভাই তিনিজন সেই তিনিজন ক'ত থাকে হয় 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 তোমাৰ মানে কাজিন আছে আৰু এইটো CAV টো চম্পকক দি দিম ন নেমিয়েন চম্পক বুলি ল'ৰা এটা আছে তাক দি দিম না চম্পক দি দিব কেতিয়াবা মানে তুমি CAV তুমি বহি আছা CAV হ'ল তেতিয়া মানে CAV অৰ্ডাৰ এটা পাছ কৰি থব লাগে আৰু মানে উকিল কেইটাৰ নাম লিখি থব লাগে তেতিয়া জাজমেন্টটো বনাওতে উকিল কেইটাৰ নামটো মানে পোৱা যায় Damien.
কোনে লগাইছে অ ছাৰে ছাৰে লগাব পাৰে চিনিয়ৰ মানুহ কিন্তু মানুহজন জেলত আছে নেকি? অ গোলাঘাটৰ কেছটো ন? অ গোলাঘাটৰ কেছটো অ।
Yes. Where is your written statement?
ৰেকৰ্ড আছে।
Oh, it's in the record. Okay.
Lordship for the impugned order,
Yes.
page number 44, Miller.
Yes.
Page number 44 is the serial number para 4. May I read, Miller?
Yes.
As regard to the school transfer certificate exhibit 9 of the Prosody DW1 is concerned, the author thereof, namely Sri Prasanna Kumar Kolita, who had already gone on supination way back in 2019, has appeared before the tribunal whose deposition was recorded as DW3. However, in producing the original record pertaining to exhibit 9, he is being joined by his successor in office, namely Sri Rupalim Sharma, whose deposition is also recorded as DW2. By the deposition of DWs 2 and 3, first of all, Prosody DW1, namely Hazrat Ali son of Zamiruddin, has not been identified by them. Secondly, both DW 2 and 3 have disputed about the date of birth of the Prosody DW1, that which mentioned in Exhibit 9. However, in her deposition, the DW2 has strongly negated about the entry of the date of birth, which reflected in Exhibit 9, contending that the date of birth entered in Exhibit 9 as 1/10/1959 is absolutely incorrect, and actually date of birth of the Prosody DW1, namely Hazrat Ali, ought to have been inserted as 31/9/1959. The calculation sheet as made in this behalf by DW2 is attached with the deposition of DW2. It has page number 3 of the deposition DW2. On the other hand, the DW3 has stated in his deposition that though he has mentioned the date of birth of the Prosody DW1 as 1/10/59 in Exhibit 9, but in true sense, it should have been inserted as 31/10/1959. However, a calculation chart prepared by him in this behalf is attested with the deposition sheet of DW3, marking the page 3 of the deposition sheet of DW3. It is not understood why, next page, Milord. It is not understood why the two school authorities have been agitating among themselves as regards.
Just a moment. Yes.
Maila. Page number, I was reading page number 45, Mila.
Yes.
Understood why the two school authorities have been agitated among themselves with regard to the entry of the date of birth of the property DW1 entered in his certificate marked as Exhibit 9. In his deposition DW3, it is further stated by him that Exhibit 9 is the duplicate copy of the school certificate, whose original copy was issued on 25/1980, having serial number 21 thereof. However, neither DW2 nor DW3 has produced the original copy of the transfer certificate in question, being serial number 21 dated 25/1980 or the counterfoil copy thereof. In this behalf, the prosecutor DW1 named Hazrat Ali has absolutely failed to mention anything as to why neither he could produce the original copy of the school certificate issued on 10/5/1980 nor made any statement in this behalf as to how his original school certificate got disappeared. Besides, the above, the DW3 has also deposed that while Prosody DW1, that is Hazrat Ali, admitted in the school, his admission was granted for the academic session 1969 in class 4. It is really very disgusting to say that academic session of 1969, as deposed by DW3, if the student, namely Hazrat Ali, son of Muhammad Zamiruddin, was admitted in class 4 and thereafter again in the session of 1970, if he was admitted in class 5, then how this could be possible that on 30/12/1970 he left the institution by readings in class 4, 6. Moreover, Exhibit 9(1), which is the LP school certificate of Muhammad Hazrat Ali, son of Muhammad Zamiruddin, clearly indicating that 31/12/1968, the said student has left the Telia Pathat.
Just a moment.
My lord. Last parameter, from the circumstances above, it presumed that DW3 has intentionally misplaced, dislodged the original school certificate, original copy of the school certificate, school transfer certificate issued on 25/1980, as well as the counterfoil copy thereof, in collusion with the present Prosody DW1, who has failed to substantiate the fact that where did the original certificate had come. Above part, DW3 has, as admitted by him, had retired from the post of principal of Juria Higher Secondary School in 2019, and just few months of the date of superannuation, he had issued the school certificate, a white Exhibit 9. In this regard, a view was taken by the Honorable Supreme Court in next page, 9 of Union of India, Azad versus Kantilal Hemataram Pandya, reported in the so and so, holding that the document appeared to have been brought into existence for the benefit of the pending proceeding therein. Apparently, in the case in hand, the reference was made in 2007, which got registered by the tribunal in 2011, and as much time thereafter, the proceeding was initiated on 15/3/2018, just a month therefrom. Exhibit 9, it was issued on 24/4/2018. From the above discussion in respect of Exhibit 9, more particularly in the above manner, I am of the conclusive view that the same has been obtained against an extraneous consideration in the projected name of Muhammad Zamiruddin, to whom the present Prosody DW1 is claiming to be his father. It is without any manner of doubt that the present Prosody DW1, namely Hazrat Ali, is the son of Zamiruddin of Salmoratub village, and the name appearing in Exhibit 9, including those appearing in Exhibit 2, 3, and 3A, are resemble manufactured documents in the projected name of Zamiruddin, son of Sabdul, with such name. However, the present procedure one had failed to establish any proper relationship. My lord, in this particular case, Kantilal Hemataram Pandya, it was related to the date of retirement and date of birth. Where 30 years later, my lord, the petitioner claimed that my date of birth should be 4 years later. I would like to. So there are other two judgments I would like to rely on. The Kantilal Milot Para 9. My lord. Para 9, a bare cursory look at the above document shows that the certificate was issued on 19/9/88, just a few days prior to the date of superannuation of the respondent on the basis of the recorded date of the birth and appear to be document brought into existence for the benefit of the pending proceeding. The CPO therefore rightly did not place reliance on the said certificate. The copy of the certificate, as already noticed, that had been issued in 1988, the tribunal, as a matter of indulgence, directed the respondent on 15/2/1993 to obtain an affidavit from the headmaster of the school disclosing the date on which the original certificate was issued, as also why the copy was issued in 1998. But no such affidavit was produced for reason based known to the respondent. In spite of the lacuna, the tribunal erroneously relied upon the said certificate, the correctness of the and genuineness of which was not free from doubt to grant relief to the respondent. The material on the record established that after filing the option forms declaring his date of birth as 6/9/1930 in 1960, and after filing the Provident Fund withdrawal form on 22/1980, the respondent made his representation for correction of date of birth in 1985 and 1987, but failed to substantiate his claim through any reliable and trustworthy documentary evidence. He allowed the matter rest till he neared the age of superannuation. The respondent slept over. This is the relevant portion. The respondent slept over his right to get the date of birth altered for more than 30 years and woke up from his deep slumber on the eve of his retirement on this. This is a completely different issue, my lord. Completely different issue. And my lord, also doubting the credibility of DW2 and 3. My lord, in the Nahar Singh, there is another judgment that I have given, my lord. So on the issue which was not cross-examined, my lord, that cannot be relied on. My lord, this is Nahar Singh, para 13, my lord. My lord. My lord, I would like to take a lawsuit through para 39 of Nahar Singh, just 3 lines. Submitted a judgment, my lord, Nahar Singh. Was instead of UP.
Yes,
Para 13, my lord. Of Nahar Singh,
Nahar's judgment.
My
Okay.
lord.
Para 13.
13, my lord, 13. May I read, my lord?
Yes.
My lord. It may be noted here that the part of the statement of PW1 was not cross-examined by the accused. In the absence of cross-examination on the explanation of delay, the evidence of PW1 remained unchallenged and ought to have been believed by the High Court.
I believe this was a criminal proceeding.
It's a criminal proceeding. Now I would like to, my lord, just bring your lordship attention to page 40, my lord. Page 40. The first
40 of
the
the writ petition.
My writ petition.
What is that?
For the state, none, my lord.
Oh, that's okay.
My lord, now the credibility of DW3 is being questioned here. A criminal element is brought that in collusion with the DW1, as if this document has been manufactured. My lord, there
Absolutely. We are also the same view. This document is manufactured. There's no doubt about it. You want to satisfy yourself about the manufactured document? We show you this. E2 flag, huh? Hmm. Now you see, out of these two, one of the headmaster comes to school and says that I bought my attendance register. Correct?
My lord.
Now there must be some reason why this this petitioner did not have it exhibited. There must be some reason. Now the reason is there. You see that document. Open up this document.
The flagged one?
Yes, yes, yes.
Yes, my lord.
Correct. Now this is on the top. See what is the date of the document? 1969.
Mm-hmm. 6, 5.
First page, second page. 1969. Class 3.
My lord, exhibit 9, my lord?
Yes.
Yes.
Not exhibit 9. I have given you that
Oh, yes,
document in
yes,
orange
yes,
flag.
Tritiyaman. Yes, my lord, Tritiyaman.
That is attendance sheet. This school register. No, in the
This is
you have
30.
left it. It's previous to that. I have
Yes, yes, yes.
given you a flag.
Yes, my lord.
Attendance. This is attendance register of 1969. Is 68 or 69?
69.
69. Yes, he's in class 3. Right.
My lord. Yes.
Next page. 69, class 4. Correct. So in 1970, you have a transfer certificate of class 6.
Yes.
And therefore the 9-1, exhibit 9-1, which is the certificate of 1968, seems to be authentic that you were in class 3. Therefore, if the documentary evidence is there at class 3, 1970 at class 6, you can't demonstrate. Unless you show us a school certificate showing that he got double promotion. This is one. There's another aspect. Mr. Aman,
My lord.
there's another aspect. I can understand sending child to a boarding school. Accepted. But he stays in Golaghat, sends a son to school at Nogam.
No, my lord, then they were the resident of this Samdora village only, because he shifted in 1975. 1975, that is a matter of record, my lord. Like 1965 and 70 from this village,
From the same village.
same village, Samdora. There is no doubt about it.
But then this document is incompatible with your certificate. In 1970, he's studying in class 5, 6.
May I get some time and bring instructions, because I have no clarity over this.
No, we know this because you see, that's the normal query we had. We think in the negative first. If the document was produced, why it was not exhibited? That was the court query. And therefore, we looked into all the records, entire records. And then we found out the reason why. And that is why you see, now we also understand the pattern, what has happened. The calculation mistake is a mistake of the DW 2 or 3, whoever has done that calculation. That is a mistake, it's excusable, because now we got the reason why that mistake happened.
But my lord, if I may submit this, my lord, even this register, my lord, on the face of it, this looks authentic from 1969 only.
But it doesn't match.
It
You
might
see,
not.
entries, no.
There are
Might,
inconsistencies. I agree with you, lord.
it's not a question of might. We don't give evidence with regard to probability. It may be this, maybe that. That's not the evidence. Evidence is evidence on fact. It must be a relevant fact within the meaning of Section 5 of the Evidence Act. And therefore, what is relevant can only be the admissible evidence, not the irrelevant evidence. And this witness inadvertently, in our oral statement, says that about the attendance register. So even if it's not exhibited, but then there are two inconsistent certificates, 9A and 9.1, and those are exhibited.
What generally happens, my lord, when taking admission in higher classes? You submit the certificate of earlier school. Submit the
No,
certificate.
we're not doubting it,
My lord.
but the document speaks for itself. If the document cannot speak for itself, it's a false document. So you don't have to dwell much on that. Either it is admissible or it is not admissible. Once you exhibit that, then it must be demonstrated that to be correct. And therefore, the first judgment which you said that was not relevant becomes relevant because of the fact that in the circumstances under which exhibit 9A and 9.1 is in existence. You must have an answer. Why this inconsistency? Why, you see, if the evidence is to the effect that it's a secondary evidence, it has to be secondary because 9.1 becomes a primary evidence. Then you had a document and you proved the duplicate copy. And this document does not have a marking of duplicate. That makes the document wholly unreliable. So we don't need any case citation to build up, to structure our judgment.
My lord,
And no amount of your instructions will improve it or change it.
lord, may I say this, my lord? In the admission register, it says he was reading class 4.
Year is 1969.
69. In the school certificate, it says he passed class 6.
No, he is reading in class 6.
Here, my lord, in the last column, it says it's class 4. It's 1B Roman.
That exhibit 9, see from your brief.
Yes, my lord.
See
That-
from your brief at this page 74. She was reading.
Yes, my lord.
I have difficulty in remembering names.
My lord is correct.
But when I read this evidence, somehow it captures
He
me.
was reading in class 6. My lord is correct. But I'm going through this. It says he was reading in class 4. The 1969 document says he was reading in class 4. In the certificate,
In 70, he's in 6. There must be a double promotion.
in the 69, my lord, he was in class 4. So which matches with the earlier document 991.
Then
So-
why 91 was not exhibited?
9-1, like I said, my lord, I don't have any because I have also not annexed it, and it was not in the annex. I did not have this document. My only point, my lord, that a 1969 admission registered says he was in class 4, which proves his existence.
No. Maybe perhaps we have not been. In fact, we are very good, very bad communicators. We don't know how to express ourselves. You see,
Not your thoughts.
very simple. It is your case that he was in class 6. Your evidence is class 6. It is the contradictory evidence of the headmaster which comes and says now it becomes a dispute. Now the headmaster says why this she has bought this admission register. Admission register having not been proved. You see, the primary evidence was not proved. It was available before the trial court. Now you forget about everything else. Exhibit 9A, 9A91. Forget about that. Primary evidence was available in the trial court, in the tribunal. That was not exhibited. That damages your case otherwise also. Even if you don't go into all these intricacies of the time and age, if you omit that also, then also the primary evidence was available and not exhibited. This document becomes wholly unreliable. Exhibit 9A and 91 both. We
Only
don't
point-
even have to go to exhibit this unexhibited document.
But this was brought, it was before the tribunal. 1969. It proved the existence of the petitioner. That is my only point here, my lord. I concede that there are inconsistencies, but
It's not inconsistency, it's a lack of evidence. Once the primary evidence is there, secondary evidence would not become available, entertainable. In view of in view of the
you know, I tell you, lawsuit, but it's one matter. Item number 9, where
One of the most adjourned matter. Yes.
that I understand. Lord. In fact, this matter I have been engaged now. My lord, can it be taken some other day, my lord? On
We have considered on 29th, my lord.
29.
29th.
29th.
Okay. But this is a,
I understand.
in our
I am
calendar,
sorry.
this is a flag matter.
That's lordship is right, my lord. In fact, my lord, various advocates were engaged in different times. This is a old matter. I understand, my lord.
Okay. And by the time 2 or 3 years have passed, it has almost become infructuous.
Lordship. That's right.
Because
But my
we
lord,
wanted to control fees. That has almost become a history now.
That's right.
Okay.
The
All
case-
sides all sides, including Mr. P.K. Roy and the senior counsel are present. Next para. The learned senior counsel for the petitioner prays for adjournment. Next para. After some discussion, the consensus has been arrived at the bar that the matter be taken up for hearing on 29/7/2025. Next para. Where is allowed? List on 29/7/2025.
I would like to conclude my argument by saying that, my lord, that all the documents may be considered. And because, my lord, the burden is on me, my lord. And that's why the preponderance of probability, the principle applies in these cases.
What is the specific statement with regard to the difference in the name of the father of the petitioner, projected father of the petitioner? What do you have to say in that? Apart from showing that judgment of Supreme Court.
Statement has been made in the written statement that is the same person.
Pardon me?
The same Zamiruddin and Zamiruddin are the same person.
Okay.
And the categorical statement being made in the written statement.
Okay. Yes. Mr. Sharma.
Lordship, my humble submission is that, Lordship, there is no infirmity in the opinion passed by the learned tribunal, and apparently, Lordship, petitioner failed.
Just on. Our smile is nothing to do with you.
My lord.
Something else cropped up. Yes.
Lordship. Apparently, Lordship, petitioner failed to establish his link with his projected father Zomiruddin, whose name reflected in the 1965 voter list at village Samdhora, Moja Juria, Thana Rupuhihat. And Lordship, regarding
Ms. Hammond, please give the paragraph numbers in the top. I might remember it. You had given us 4 judgments. Idris Ali,
I will,
Kantilal,
yes.
then
I'll
Har
mark it.
Singh, and Sirajul Haq.
Right.
Yes, 4 judgments.
Yeah.
Into your face. No. Just give the paragraph. No.
Moving on.
Yes.
then Lordship, petitioner is relying on voter list of 1985 Lordship at page Lordship, voter list of 1997 at page 40. And prior to that, Lordship, there was no voter list in respect of the father, in respect of the proceeding Lordship Hazrat Ali.
Page 40,
67 Lordship.
67.
At the age of 40 years, Lordship, his name first time reflected, Lordship. Prior to that, Lordship, there is no voter list of his father as well as proceeding himself, Lordship.
This is
Since
electoral roll of
1997, Lordship.
1997. Where is this 1997 given?
Page 67 of the writ petition. Different village, Salmora 2.
No, because this document does not say electoral roll of 1997. It just says it is revised up to 1/1/1997.
Yes, Lordship.
So is it, shall we presume it to be a voter list of 1997?
My lord.
Certified to be true extract from the electoral roll of the above mentioned constituency, revised with respect to 1/1/1997 as the qualifying date. So, prior to that, Lordship, since 1970 to 19,
No, because here there's a catch. That's why we are asking you again.
Lordship.
It doesn't say that this is a certified copy. It
Yes,
merely
Lord.
says certified to be true extract.
Yes, Lordship. Certified to be true extract from the electoral roll. And Lordship. Yes, Lordship. And prior to that, Lordship, proceedee is unable to place any other document, Lordship, since 1970 to 1997, Lordship. And Lordship, although statement has been made and Lordship, a different sale deed has been placed before the tribunal, Lordship, but by this document also, proceedee failed to establish his link with his projected father, Jamiruddin, whose name reflected in the 1965 voter list. Then Lordship, another important aspect, Lordship, although proceedee stated that his mother's name is Tahira Khatun during the time of evidence, filing of evidence, Lordship, but he is totally silent regarding his mother's name during his pleadings, Lordship. In WS, no nowhere proceedings mention his mother name, Lordship. Why it was not mentioned, Lordship? You don't know. And Lordship, it is settled law that proceeding cannot go beyond pleadings, Lordship. Regarding that, Lordship, I am going to rely on Rosminara Begum's case, Lordship. Two 2017 for GLT 346.
The name of the mother is in any voter list? No.
65. After that, Lordship, 60. Only 65 voter list, Lordship. There is also a lack of continuity from 1970 to 1997, Lordship. As per section 682 of the Citizenship Act 1955.
Please repeat again, did not get it.
Lordship, regarding continuity, Lordship, there is a lack of continuity.
What's a lack of continuity?
Continuity. Since 1970 to 1997, Lordship.
From
1970 to 1997. In this regard, I am relying section 682 of the Citizenship Act 1955, Lordship.
Citizenship Act section
682. And regarding pleadings, Lordship, I am relying Rosminara Khatun's case 2017 for GLT 346.
Rosmina Khatun's case, no?
Yes, Lordship. Rosminara Begum, RASHMINARA BEGUM, 2017 for GLT 346, para 25.
346.
Yes, Lordship. Para 25. Written statement is the basic statement of defense of a proceeding before the Foreigners Tribunal, keeping in mind the mandate of Section 9 of the Foreigners Act 1946. It is incumbent upon the proceeding to disclose at the first instance itself, that is, in his written statement, all the relevant facts, especially within his knowledge, having a material bearing on his claim to citizenship of India. Material facts pleaded in the written statement are thereafter required to be proved by adducing cogent and reliable evidence. It is also tried that party cannot reverse beyond the pleadings made in the written statement. Then, Lordship, only remaining document is school certificate, Lordship, by which proceeding is trying to establish his link with his projected father. And Lordship, has already pointed out, Lordship, two headmasters come before the tribunal and depose before the tribunal, Lordship, and both the statements are contradictory statement.
Statement is not contradictory. We have two set of questions for one set of for him, one set for you.
Lordship.
You see, what has happened was, I mean, we told you a nursery rhyme,
Lordship.
30 days in September. So there could not have been 31st day of September.
Lordship.
It should have been 1/9. If it is so if it is 1/10, then the statement is correct.
Lordship.
It is just because the headmaster does not know how to calculate. This has happened.
Yes,
Neither the headmaster consulted the calendar, nor the advocate and the tribunal saw the calendar.
Yes,
They found it very difficult to look at the calendar.
yes, Lordship.
Even if you make a calculation and sometime come that what you call, let us say that if his age is so and so, then he would be born on 32 January. If you make a calculation like that
Yes, yes.
and you make it before us, we must know that the calendar has 31. So the reference to 32 will always be 1st of February,
Yes, Lordship.
correct?
Yes, Lordship. Yes, Lordship.
And you know why I know about it.
Lordship.
I wear a very old dated watch.
Lordship.
It has automatic day and time.
Yes, Lordship.
So every time in non-31st, what do you call, month,
Yes, Lordship.
it gives a time difference of 1 day.
Yes, Lordship.
So I have to adjust it. So every month I am reminded that this is which is this month.
Lordship.
And this is just because I have not updated myself. I don't have a smartwatch.
Yes, Lordship.
So I have to be smart to know the date.
Lordship.
So if there is no 31st March, no 31st of September, everybody should have
Yes, Lordship.
noticed it.
First day
So
of
there it will
October.
be first, then both statements are right.
Lordship. Lordship.
It is for Mr. Hazarika to take note and recommend their future career of these headmasters. You have seen you have seen this record. It is
Yes,
with you.
yes, Lordship.
In the evidence third page, look at that. They said that I have made a flag.
Yes,
I've given a flag there.
yes, Lordship.
No, down below. There's a flag somewhere. No, not here. It will be down below.
Headmaster's evidence, Lordship.
Yes, down below.
Yes.
Next.
Third page. I have flagged it.
Next. It will be. It will note to the important query.
You have seen the calculation.
Yes, Lordship. Lordship. Yes, I have seen. 31/9/1959.
But ADC on the spot before the tribunal.
We don't know. We don't comment anything.
Lordship.
Everybody has their wisdom. We won't say anything.
Lord.
But we caught it because I was what you call antedated.
Lordship. And Lordship.
And no, this is something which is wrong. The tribunal could not have done it.
Yes, Lordship.
But you see why? The tribunal cannot say, I refer to a calculation sheet at so and so.
Yes.
Because this is not a part of evidence.
Yes, Lordship.
So the tribunal, by referring to this, has traveled beyond evidence. The tribunal could have asked and made it an exhibit. It was a query of the court. And you see in the top what the court writes? Tribunal?
Important query.
Huh?
Important query.
Important query. So how can a query be brought on record without
Yes, Lord.
it being a part of the evidence?
Yes.
That means the tribunal does not know how to put questions under 165.
Yes, Lordship. Lordship. Just like cross-examination, Lordship. Then, Lordship, I want to read DW3, Lordship, evidence of DW3 from the record, Lordship, in vernacular, Lordship. মই জুৰিয়া হায়াৰ ছেকেণ্ডাৰী স্কুলৰ প্ৰাক্তন অধ্যক্ষ হওঁ। মই 2016 চনৰ উক্ত বিদ্যালয়ত অধ্যক্ষ আছিলোঁ আৰু 2019 চনত অৱসৰ গ্ৰহণ কৰিছিলোঁ। মই হজৰত আলী পিতা মহম্মদ জমিৰ উদ্দিন গাঁও চামধৰা জিলা নগাঁও নামৰ ছাত্ৰজনক মই কাম কৰি থকা বিদ্যালয়খনত প্ৰদৰ্শক 9-1 ভিত্তিত চতুৰ্থ শ্ৰেণীৰ 23-1-1969 ইংৰাজী তাৰিখে ভৰ্তি কৰা হৈছিল। মই জুৰীয়া উচ্চ মাধ্যমিক বিদ্যালয়ত অধ্যক্ষ হিচাপে দায়িত্ব লোৱাৰ সময়ত উক্ত ছাত্ৰজনক ভৰ্তি কৰা হৈছিল
No, no,
কিন্তু
no, this may not be true. We look at the first page, first flag, where we have produced the reference to the, no, not this, first one, that admission register. Is the date available? No.
yes, Lordship, in record.
It's not there. Cut down to next page.
Yes, yes.
Is the date of admission there? No.
The transfer. No. Date of transfer certificate. Hmm? Date of transfer certificate. Certificate.
That part is transfer certificates.
Date of admission is not here, Lordship. First admission.
Second page is class 4. It doesn't have a date.
Lordship. Oh. Thoroughly.
Same page আছিল তো ভাগ ভাগ কৰিছে এইটোৱে হ'ব এইটো তেলিয়া পথাৰ এইটো স্কুলৰ পৰা
Class 3.
এইটো
Teleopter 3 B.
এইটো স্কুলৰ পৰা আহিছিলে ইয়ালৈ গৈছিল
Note of school.
Not his presumption.
Yes, Lordship.
You see, if I want to exhibit one word from here,
Yes, Lordship.
can I give this entire book to the court as I exhibit and
No.
then say that court will find out?
No.
No. You have to mark the relevant
Yes, yes, Lordship.
entry.
Yes, Lordship.
Otherwise, in bank cases, there may be lakhs of entries.
Yes, Lordship.
If one is a offending entry, you'll have to prove that. That
Lordship.
how the exhibit 1 is the bank statement, exhibit 1 by 1 is the relevant statement.
Lordship.
So that is how it is to be done.
Lordship. Yes, Lord.
And now we'll tell you the basic principle of Evidence Act. A matter which could have been proved by a document cannot be proved by oral evidence. He is not the person who has made that entry.
Yes, yes, Lordship. Yes, Lordship. Lordship. What they have stated, Lordship, মই অধ্যক্ষেশ্যন দায়িত্ব লোৱাৰ পিছত উক্ত ছাত্ৰজনক ভৰ্তি কৰা হৈছিল কিন্তু আমাৰ বিদ্যালয়ত 1970 চনৰ মূল নথিত কলম নম্বৰ 12ত উল্লেখ থকা জন্মৰ তাৰিখ মই ছাত্ৰজনৰ প্ৰদৰ্শক দিয়াৰ দিনাখন তেওঁৰ জন্মৰ তাৰিখ 1-10-1959 হিচাপে লিখিছিলো আৰু তাৰ আগত কলম নম্বৰ 12ত উক্ত ছাত্ৰজনৰ জন্ম তাৰিখৰ ঠাইত একোই উল্লেখ নাছিলে লৰ্ডশ্বিপ সো লৰ্ডশ্বিপ ছাত্ৰজনৰ জন্মৰ তাৰিখ 1-10-1959 হিচাপে যদিও মই উল্লেখ কৰিছো কিন্তু বাস্তৱতে সেইটো 31 something was erased, Lordship.
Now, just stop here for the time being and come back to that flag 1.
84 page 84
Second page of that. Second page. This is the register.
Yes, Lordship.
Now, who has made this entry of 31-9 or 110? Who has made this?
date of birth
Encircled.
Yes, Lordship.
It's encircled.
Yes, Lordship.
Now, in no other admission register, that date is there. And now this witness says that I made this entry.
Yes.
That means perhaps somebody must have asked him to do it,
Yes, Lordship.
or she has done it of her own.
Yes, Lordship.
What has happened?
1959.
Now, please read that evidence again. that part.
পদৰ একোৱেই উল্লেখ নাছিল উক্ত ছাত্ৰজনৰ জন্মৰ তাৰিখ 1-10 হিচাপে যদিও মই উল্লেখ কৰিছো কিন্তু বাস্তৱতে এইটো 31 হ'ব লাগিছিল প্ৰদৰ্শক 9 প্ৰমাণ পত্ৰখন মই 24/4/2018 ইংৰাজী তাৰিখে ডুপ্লিকেট কপি হিচাপে দিছিলো আৰু তাৰে
So now you know what has happened.
Hmm.
When the tribunal gives that page 3 calculation to make,
yes Lord.
he or she, whatever it is the witness is, writes in the document and then makes the calculation
Yes
in a separate sheet.
yes
So therefore that has come and it is not the signature, not the handwriting in which the other entries in exhibit that attend registered is made.
yes Lord.
Now we'll tell you the forensics of it. In that document,
Lordship.
you will find at the end of the entry, there's 121 or something. No, in the for second page. There's a dates 21 or something.
Yes 9322.
No,
Oh,
first no first
Yeah.
entry there. Yes, right side. Your hand is there.
10-1-22.
10-1.
Yes.
This one doesn't match with that one.
Yes, Lordship.
So this is not the same handwriting. It's not the person signing the original register.
Yes, Lord. Yes, Lordship. Lordship. Yes, Lordship. So, Lordship, how Lordship's schools registers has been proved? It was law has
School register was never proved.
never proved, Lordship. Never proved. It's Lordship. And if this school certificate goes, Lordship, then
No, we
Nothing
don't know
to our
whether it goes or not. Both of us will debate inside.
and Lordship, how to prove scholars registered, Lordship, regarding that, Lordship, Supreme Court has settled the law in Viratmal Singh's case, Lordship. 1988 Supplementary SCC 604. 1988 Supplementary SCC 604. Yes. 1988 Supplementary SCC 604.
Spelling Viratmal.
Viratmal Singhvi.
Singhavi.
Yeah, Lordship. 20.
Singhavi.
SINGHVI versus
No,
Anand.
Singhavi.
No, Lordship. SINGHVI.
VI.
Yes, Lordship. Para 14 to 17, Lordship, I am relying, Lordship.
VI. VI.
Viratmal.
VI.
Viratmal.
Singhi. Mr. Purohit.
Some portion of para 14, Lordship, I am reading, Lordship. As already stated, neither of the parents of the two candidates nor any other person having special knowledge about their date of birth was examined by the respondent to prove the date of birth as mentioned in the aforesaid documents. Parents or near relations having special knowledge are the best person to depose about the date of birth of a person if entry regarding the date of birth in the scholars registers is made on the information given by the parents or someone having special knowledge of the fact. The same would have probative value. The testimony of Antaram Sharma and Kailash Chandra Taparia merely proved the documents, but the contents of those documents were not proved. The date of birth mentioned in the scholar's register says no evidentiary value unless the person who made the entry or who gave the date of birth is examined. The entry contained in the admission form or in the scholar's registers must be shown to be made on the basis of information given by the parents or a person having special knowledge
But
about the
here in this Viratmal doesn't help you anyway.
Lordship.
The reason is that in the evidence, although the court has not recorded, the tribunal has not recorded and exhibited this school register, but the tribunal has referred to the school register. And the witness says that I bought the school register
Lordship.
and gave the evidence. So therefore, the ratio of the Viratmal is quite what you call complied with.
Lordship.
The proof is one thing, but bringing of the register and proving the contents is another. Second part, they have done it.
Yes, Lordship.
And the witness says that I have bought the school register.
But basis of the entry made in the register, Lordship, there has
It's
also
not been questioned. The question posed was immature question. Making entry of just 31st of September and 1st of October. There's not a substantive evidence at all.
Lordship.
Even if this evidence stands, it will have no value. They cannot be 31 September in a calendar. Calendar means Gregorian calendar.
Lordship.
If the tribunal has a different calendar, we don't know. English Gregorian calendar, if it is there, 31st is not there.
Lordship. In Assamese calendar, Lordship, there is a 32 numbers of dates, Lordship. In Assamese,
No, it may happen this way. I modified my statement.
yes, Lordship. And apart from that, all other statements are oral statements, Lordship. And law has regarding that, Lordship, already settled, Lordship, or Vijay Das case, Lordship. So, Vijay Das to let এইখন
You see here. It was a General Clauses Act. General Clauses Act. I said, I show it to him, this one. This is 35, 235, definition clause, General Clauses Act, 35, month.
month.
Yes.
Reckoned according to British calendar.
So this Assamese calendar won't work here.
Lord. Lordship. Lordship may Vijay Das case, Lordship, I am relying regarding oral testimony, Lordship. 2018 3 GLT 118.
That is,
2018 3 GLT 118.
which case?
Vijay Das. Bijoy. Vijay Das.
2000?
18 3 GLT.
Page.
Page 118.
What is the proposition?
Then Lordship, it is tried that mere filing of written statement or oral testimony in a proceeding under the Foreigners Act 1946 should not be enough. The fact in issue would have to be proved by the proceedee by adducing documentary evidence which are admissible and relevant. The two documents filed by the petitioner were not proved in any manner whatsoever, and therefore assertion of the petitioner that he being the son of Bipul Das, who was a citizen of India, was therefore a citizen of India, was not proved. Lordship,
Which paragraph?
Para 17, Lordship. Oral testimony. It is tried that mere filing of written statement and oral testimony in a proceeding under Foreigners Act 1946 would not be enough. The fact in issue would have to be proved by the proceedee by adducing documentary evidence which are admissible and relevant. And so many decision has been passed by this honorable court regarding oral testimony, Lordship. Yes. মা-দেউতা কেতিয়া ঢুকাইছে কৰিছে নেকি আপুনি? মা-দেউতা কেতিয়া ঢুকাইছে কৰিছে নেকি? Parents? এভিডেন্সতো পোৱা নাই। এভিডেন্সো মোৰ ওচৰত নাই। দিয়া নাই। WF এভিডেন্সই পাইছে।
Yes, Mr. Sharma.
Yes, Lordship, and Lordship, what happened to his parents after 1970, Lordship? That was not mentioned neither in evidence nor in written statement, Lordship. These are vital things, Lordship. Petitioner is to place before the tribunal at the first instance, Lordship. After 1970, Lordship. What happened to his parents, Lordship? That was not mentioned, Lordship.
Jonathan. Jonathan Lee Riches. Jonathan Lee LW Riches. Yes, yes, yes. Yeah, that's what. Jonathan Lee LW Riches RSCs. I think this is legal.
Evidence too.
US Supreme Court, not court correct. You know, first of his. Why did you say what is the only prohibition? Because never happened. Nothing to do with this. Yes.
Lordship. That's for Lordship. If schools are only aspect is Lordship school certificate. If school certificate petitioner is not able to prove the school certificate, then Lordship there is nothing to prove his linkage, Lordship, in respect of his projected father whose name reflected in the voter list of 1965, Lordship. That's all, Lordship.
Okay. Anything in reply? Mr. A.W. Hamal, counsel for the petitioners, or the respondents are there. The submissions are concluded, judgment is out.
Item 19, my lord, adjourned for the day.
What says advocate on the prayer made by counsel for the petitioner? List after 2 weeks.
Grateful.
Item 7.
Case, this is also a contested case, Lordship. At the time of filing, we have annexed some documents And some documents were not annexed, so later on we have filed additional affidavit, Lordship, annexing those documents.
এইখন affidavit নাই। আছে নেকি?
Which page is your written statement?
Treatment, Lordship, that is the. Page 25.
মুছলিম এইটো প্ৰতিটো পাম নাই। এইটো কিছু নাই।
The written statement was filed on 30/3/2017. May I read? Lordship?
Yes, and your evidence?
Evidence, Lordship, that is page. Page 30, Lordship, annexure 7.
তাত ফটো মাৰি পেলাই মোক দি দিয়কচোন মোবাইলত। দি দিব লাগিব।
Which is the voter list where your name appeared first?
1985. Page, Lordship, 22. Page 22, Lordship. Annexure 3, name of electors, Lordship, Bashibuddin instead of Basiruddin, my father, Lordship. And my grandfather's name is late Alam Sheikh against father's name, Lordship.
Page number 22.
22, Lordship. Serial number 671, my father. Serial number 672, Hasena Vanu, my stepmother. Six 73, the petitioner himself. 674, his wife, Lordship, Malika Khatun.
Something missing, I think.
Page 22, Lordship.
In your written statement, have you referred to your
Written statement and evidence, I have stated that in 1985, my name appeared along with my stepmother. Para 7, page 26, written statement. Page 26, para 7, last paragraph, Lordship, that the mother and stepmothers of opposite party.
no,
lie-
your 1985 voter list, where is that?
Page 22, Lordship.
22. 22, now you say that Hasina Banu
My
Was your,
stepmother,
was your stepmother?
yes.
But look at this, that's why I was referring to your, this, when you come to page 26. Para 7, your mother and your stepmother died around the year 1975.
Mother married 4 times. So my mother and stepmothers died after death of 3 wives, lordship. The Hasena Banu was married. And she.
But there's something which is missing. I don't find anything where your grandfather had married 4 times.
No, lordship, that the mother and stepmothers of opposite party died around in the year of 1975 in separate dates, and accordingly father of the opposite party got married another wife named Hasena Banu, and in the meantime the opposite party attained age of majority, and as such name of the opposite party is enlisted in the voter list of 1985 with his father, his stepmother and his wife by serial number 671 to 674 in house number 155, Ambari polling station 65, Ambari ME school. Before that, lordship, in paragraph 4 and 5, we have stated that my father's first 3 wives' names are there, lordship.
Okay. Your name is Ahmed Ali.
Ahmad Ali, lordship.
Okay.
Kindly see, lordship, annexure 6, page 25, paragraph 5, that the father's name of opposite party is Basiruddin, son of Almu Sheikh, as well as other family members' name is enlisted in the voter list of 1966, by serial number 105 to 111, house number 36 under Abhayapuri SC Legislative Assembly constituency as page 26, Basiruddin, son of late Almu Sheikh, Kuliman Nessa, wife of Basiruddin, Rasun Khatun, wife of Basiruddin, Moiful Nessa, wife of Basiruddin, Abu Bakr, son of Basiruddin, Habibur Rahman, son of Basiruddin, Tara Banu, wife of Abu Bakr, as a bona fide Indian citizen. A photocopy of the said voter list of 1966 is annexed herewith and is marked as Annexure 1. That 1966 voter list is Exhibit 1, lordship. Page 18, lordship.
Yes.
Page 18 is the type copy and original is page 19. My father's name was there, lordship, Basiruddin, against his name late Alamu Sheikh, lordship, grandfather.
Yes.
Kulijan Nessa, mother, Rasun Khatun, mother, Moiful Nessa, my own mother, lordship. 2 are stepmother, and Moiful Nessa is the own mother of the OP, lordship. Then on attaining majority in 1985, his name appeared along with his stepmother, 4th mother, lordship, Hasena Banu. Annexure 2, page 20, 1970 voter list. Same place, lordship, Ambari. Basiruddin against his name late Alam Sheikh, grandfather's name, Kulijan Nessa, stepmother, Rasun Khatun, stepmother, Moiful Nessa, own mother, Abu Bakr, elder brother, Habibur Rahman, elder brother, Tara Banu, sister-in-law, lordship. These are 1966, 1970, Ambari, lordship. Then 1985, Annexure 3, page 22, same place, Ambari. Petitioner along with his wife and father and stepmother, lordship. Nineteen 1997 voter list, page 23, Annexure 4. Page 23, Lordship, serial number 10, Ahmad Ali, against his name, late Basuruddin.
Ms. Jolly, please take a seat for 2 minutes.
Lordship.
Just
আমি তো কিছু করতে নাই কেউ বিযোগ করে এটা হচ্ছে Learned Tribunal, Lordship, page 36. The decision is given. In this case, no prosecution witness has been examined, but to prove himself not to be a foreigner, OP has submitted his evidence on affidavit. In his affidavit, OP stated that he is son of late Basiruddin, aged about 55 years, and a resident of village Ambari, PS Abhayapuri, district Bongaigaon. OP stated that
his father's name is recorded with other family members in the voter list of 1966 and 70. OP stated that his name is recorded along with his father and other family members in the voter list of 1985, Exhibit 3. OP stated that he has landed properties and obtained periodic Khiras Patta in his name, Exhibit 4. OP stated that Exhibit 5 is the Jamabandi of said landed property. OP stated that after the death of his father, his name is recorded in the voter list of 1997 and 2013, Exhibit 6 and 8. OP stated that Election Commission of India has issued him an elector photo identity card, Exhibit 8. Earlier should be Lordship Exhibit 7. OP stated that he has inherited a landed property from his father, and Exhibit 9 is the Jamabandi of the said landed property. To come to a just conclusion, let me appreciate the evidence on record along with the aforementioned 9 documents to determine the nationality of the opposite party. From record, it appears that OP has tried to project Basiruddin as his father, whose name is recorded in the voter list of 1966 and 1970, Exhibit 1 and 2. In Exhibit 3, as per OP's name is recorded along with his father and stepmother. There is a translated copy of voter list is in respect of the year 1985, wherein name of his father is recorded as Basiruddin and age of his father is shown as 85 years. If the age of OP's father is considered from the voter list of 1966 and 1970, which is shown as 45 and 54, then the age of OP's father is a father in 1985 would have been 69 years. Lordship, pausing for a moment here, Lordship, 1966 voter list, if we see, the age of the OP's father is written as 50, Lordship. Page 19, Annexure 1. Basiruddin is aged about 50 years in 1966. But that was, Lordship, after going through the voter list also, the tribunal recorded it as 45. Instead of father in 1985 would have been 69 years instead of 85 years. Apart from that, name of his mother is recorded Hasina Banu. OP stated in his evidence in chief that his 3 mothers expired around 1975 in different date.
Please repeat again. What is the error?
Lordship, in 1966 voter list, which I have exhibited, my father's age shown as 50 years, Lordship.
1985.
1966, Lordship.
66.
Yes,
Okay.
Lordship.
45 years. Yes.
45 years recorded by the tribunal, Lordship. But in fact, the voter list shows the name, age of father is 50 years.
50 years.
Page 19, Lordship. So, Lordship, after going through the exhibit also, and the documents are very much present in the record, even then tribunal can, Lordship, wrongly write age as 45 years. Then there should be some discrepancy in the voter list while preparation of the voter list by the respondent authorities, Lordship.
What is the year to say, it was
The tribunal himself committed wrong in writing the age from looking after the voter list, Lordship. And now preparation of the voter list, Lordship, the respondent authority have committed some wrongs. There is no mistake on the part of the petitioner, Lordship. Apart from that, name of his mother is recorded Hasina Banu. OP stated in his evidence in chief that his 3 mothers expired around 1975 in different date. Accordingly, his father got married with another wife, whereas on his statement recorded before this tribunal, OP stated that his father got married in the year 1990. Interestingly, his name appeared with stepmother in 1985. That is the discrepancy as stated by the OP, Lordship. In oral statement, he stated that his father got married in the year 1990. Maybe there is a mistake by the OP while disclosing the year, Lordship. He was aged about 55 years on that day of recording statement, Lordship. But 1985 voter list is there. His mother's name was there, Lordship. Lordship, the documentary evidence will prevail over the oral statement. But the learned tribunal said that, Lordship, due to the discrepancy as stated by the OP, interestingly, his name appeared with the stepmother in 1985. So he stated that in 1990, my father married Hasina Banu, but her name, before that, her name appeared in 1985 voter list.
Yes.
This voter list contains serious discrepancies in the name and age of OP's father, which creates doubt about the genuineness of the said voter list. Moreover, this voter list is a translated copy, therefore cannot be considered as secondary evidence. Exhibit 4 is a periodic Khiras Patta in the name of OP as son of Basiruddin. Exhibit 5 is stated to be the Jamabandi of the above land. This computer-generated copy of Jamabandi is not certified by the competent authority. That Jamabandi I have enclosed with my additional affidavit, Lordship. Page 47 of the additional affidavit, Lordship. But I have seen there are signature of circle officer and compared by Lot Mondal. Page 47 is the own land of petitioner, patta number 45 and patta number 479, page 49 is inherited from father, Lordship. Page 49 also, Lordship, there is a signature of circle officer and verified and found correct by Saidul Islam Lot Mondal, lot number 5, Srijangam Revenue Circle. Irrespective of that, Lordship, the electronic, the Jamabandi downloaded from electronic record, Lordship, is admissible in evidence, Lordship. So, Lordship, and hence not acceptable and admissible. This was the ground assigned by the learned tribunal, Lordship. Exhibits 6 and 7 are stated to be the voter list of 1997 and 2013, wherein OP's name is recorded. By this voter list, linkage between OP and his projected father is not conclusively established. So, Lordship, the 1966-1970 voter list were not taken into consideration. There was no discussion why those voter lists were not taken into consideration. There, the father name is there, Lordship, and along with father, OP's name is also there in 1985. Exhibit 9 is stated to be a copy of Jamabandi of landed property inherited by OP after the death of his father. This is an uncertified computer-generated copy of Jamabandi wherein mutation order was passed by the circle officer Srijangam on 29/5/17. OP failed to provide related land document of this property to ascertain the prior status of the land. This document would be of no use to the OP for determination of citizenship status OP. For reasons and discussions above, the evidence and the documents submitted by OP in support of his version are found to be not sufficient and trustworthy to prove that he is a citizen of India by birth and not a foreigner or illegal migrants. On these grounds, his documents were not taken into consideration. But Lordship, the 1966 and 1970 voter list are not translated copy. These are certified copies, Lordship.
We remember that on the last occasion we discussed about this.
Lordship.
1 and 2 are certified copies,
Lordship.
and rest are not.
Lordship. And then 1985 translated copy. Maybe there was a procedure in 1966 and 70 to give the certified copy from the original copies, Lordship, after making photocopy of the original documents. And later on, they have opted for translated copy of providing the certified copy in a translated form, Lordship. For this, Lordship, I want to rely this judgment already on that day also I have provided this.
What is the
Lordship, that day also I have provided Moniruddin judgment, Lordship.
Moniruddin?
Yes, Lordship. Para 29 voter list, Lordship. In respect to NRC also, Lordship, there is a finding in paragraph 28. And even if NRC details are not admissible, that can be taken into consideration, Lordship.
Para 28
Para 28 NRC, Lordship, but in this case.
of this judgment.
Yes, Lordship. But the petitioner has not exhibited any NRC document, so I am not relying that paragraph. But only for Lordship, our knowledge, it is that NRC documents are also in that judgment stated that if the NRC document is not admissible, then only, Lordship, we can take benefit as because those persons were living at the time of preparation of NRC in the state of Assam, Lordship. Now, Lordship, discrepancy about voter list, page para 29. As regards the observation made by the learned tribunal relating to exhibits 1, 2, and 3, which are voter list of 1966, 70, 1985, that the persons whose names appeared in exhibit 1 voter list of 1966, exhibit 2 voter list of 1970, along with the proceedings father and mother, did not appear in the exhibit 3 voter list 1985. It cannot be a ground to ignore the relevancy of the said exhibits in as much as the said voter list are in respect of the same village, police station, subdivision, and district respectively. Here also same, Lordship, 1966 to 2010-16, same village, Lordship, Ambari. It may be noted that certified copies of the electoral rolls exhibited are not the complete list. They are merely the extracts of the relevant parts of the voter list showing the names of persons who the proceeding considers relevant. Typically, in a proceeding before the Foreigners Tribunal, the proceeding seeks to refer to the names of persons who the proceeding claims to be parents. It also cannot be denied that the state has an easy access to the voters list, and once the proceeding discloses the particular voters list as the basis of his claim, nothing prevents the state from verifying the same. Thus, merely because the names of other relatives are not shown in subsequent voter list will not render such subsequent voter list suspect or irrelevant so long as the name of the projected parents are shown in the same village as in the present cases. The name of Yusuf Ali, Lordship. These are the discussions in respect to that case, Lordship. Then paragraph 30. The fact that the name of the proceedings projected father was shown consistently in the aforesaid voter list in respect of same village would lend credence to the claim of the proceeding that his father was indeed a voter in 1966, 1970, and 1985, which would substantiate his claim that his father was an Indian. The learned tribunal appears to have laid great emphasis on the discrepancy in the age of the projected father of the proceeding. Such discrepancy in reflecting the age in voter list is not uncommon and cannot be said to be significant in nature and perhaps can be ignored in as much as in the present case the name of the voter who the proceeding claims to be his father along with the name of the grandfather consistently appears in the same village and constituency. The learned tribunal did not appear to have considered at all this aspect that the proceedee is also a resident of the same village, so-and-so, and his projected father, along with the name of the father, grandfather, was also shown a resident of the same village. According to us, the aforesaid discrepancies in the voter list and age as discussed above cannot be a ground to disbelieve the claim of the proceedee when the voters list refer to the same village of Dumoria Part 3. In subsequent voter list, so we have also noticed that the proceedee continued to be a voter as enlisted in the voter list as a resident of same place and under the same village police station as his projected father was. Though in the subsequent voter list, the district has been shown as Bongaigaon, it is a fact that Bongaigaon district was carved out of the then Gwalpara district, and as such the aforesaid evidence could not have been ignored by the learned tribunal as has been done. Coming to the exhibit 11, which is Kabinnama, it was ignored, Lordship, as because that Kabinnama was not proved in that case, Lordship. So it was not taken into consideration.
Kabinnama was not proved.
In that case, Lordship, in Maniruddin. Kabinnama of the proceedee wherein the name of his father has been shown as the issuing authority was not examined. We are also of the view that there was no illegality in ignoring the said document by the learned tribunal. So Kabinnama was not taken into consideration in that Maniruddin case, but the voter list and Jamabandi were taken into consideration. Para 36, as regards exhibit 12, which is a certified copy of Jamabandi, it has been ignored by the learned tribunal primarily on the ground that the proceedee had not submitted the land purchase document of the said land or the mutation order for transfer of ownership from the original Paktadar, and also that he had not stated in his written statement when he filed on receipt of the summons. The tribunal also observed that the proceedee did not mention in his affidavit as to when his projected father had purchased the land. However, we are of the view that aforesaid reasons cannot be good grounds to ignore the said document for reasons which are discussed hereinafter. Certified copy of a Jamabandi being a public document is admissible under the Indian Evidence Act 1872. In this regard, we will briefly refer to some of the judgment as also relied upon by the learned counsel for the petitioners. And thereafter, Lordship, para 37 to 38, 37 was subpara are there, some Lordship. Discussing various judgments, Lordship, the court came to a conclusion that (37.8), Lordship.
Jamabandi, there were two in this case, exhibit 5 and exhibit
9.
9.
Yes,
On which you are relying?
one patta is also here, Lordship.
On which you are relying?
Exhibit 5, Lordship, my own land, and exhibit 9, Lordship, I have inherited from my father. In both the Jamabandis, my father's name is written as Basiruddin, Lordship.
Okay.
Findings, Lordship, page, paragraph 37.8, Lordship. Page 16. We are in agreement with the learned counsel for the state that the certified copy of a Jamabandi cannot be the sole basis for claiming citizenship. However, it cannot be divested of any evidentiary value. It can show that the person named in the Jamabandi possessed the land in the locality area mentioned, and if the said Jamabandi reflected the name of Yusuf Ali Talukdar as the father of the proceedee, it can be a corroborating evidence as regards the claim of the proceedee that he is the son of the projected father Yusuf Ali Talukdar. For this, there is no need to produce the documents showing the name of the original Pattadar. In our view, non-mentioning of the name of the original Pattadar or the sale deed cannot divest the evidentiary value of the said Jamabandi in view of the decisions referred to above. Those evidences as mentioned by the learned tribunal would be necessary to establish ownership or title over the said land if there is any dispute about the title. However, in the present proceeding, we are not really concerned about the ownership or title of the said land. What is relevant is that the name of the so-and-so is found along with the other legal heirs of the sensu includes the proceeding. Thus, the Jamabandi can be used for the limited purpose establishing that the persons named therein possess certain land and about the relationship of the persons whose names are recorded in the Jamabandi, as well as the fact that they resided in the place recorded in the Jamabandi, which of course are all rebuttable. But as mentioned above, there are no rebuttal by the state on any of these aspects. We are thus not in agreement with the finding of the learned tribunal that the said Jamabandi could not have been relied on merely because the proceedee has not mentioned in the written statement as to when his projected father had purchased the said land, or the sale deed has not been mentioned for the reasons discussed above. And then, Lordship, my learned friend on that day cited Wahab Ali. Regarding Wahab Ali, Lordship, it was discussed here also, Lordship. Next, page 17, Lordship. Above paragraph 41, the claim of the proceedee based on the aforesaid certified copies of voter list. So in this judgment, Moniruddin Lordship, based on the certified copy of voter list and Jamabandi, he was declared for Indian Lordship. After his death, Lordship, in this case, the legal errors were substituted and then the judgment was delivered, Lordship. The claim of the proceedee based on the aforesaid certified copies of voter list stand corroborated by the contents of the certified copy of the Jamabandi, which being public documents are admissible in evidence and hence could be relied upon by the proceedee. This voter list and Jamabandi are admissible in evidence had been proved by the proceedee and are relevant to the key issue involved in the proceeding. Thus, as held by this court in Wahab Ali Supra, as also relied upon by the learned counsel for the state was required to rebut the genuineness of these evidences. In this regard, we would also recall the observation made by the Honorable Supreme Court in para 26 of Sarbananda Sonowal 1 Supra, in which the Honorable Supreme Court made an observation that in order to establish citizenship, normally a person may be required to give evidence of first, one is his date of birth, place of birth, name of his parents, their place of birth, and citizenship. As these facts would necessarily be within the personal knowledge of the person concerned and not of the authorities of the state. In the same paragraph, the Honorable Supreme Court further went on to observe that if a person has given evidence on these points, the state authorities can verify the facts and can then lead evidence in rebuttal, if necessary. The purpose of the said observation is that while it will not be possible for the state to gather the details of personal information relating to a person at the initial stage, because of which the onus of proof citizenship has been cast on the proceeding, once the same is disclosed and if the state does not accept or doubts the genuineness of such disclosure, the state can certainly verify and if necessary can lead evidence in rebuttal. That is the purport of the observation by the Honorable Supreme Court in paragraph 26 of Sarbananda Sonowal 1 Supra, that the state can verify the facts and lead evidence in rebuttal if necessary. In the present case, what is evident is that though the state would not be expected to know the details of the father of the proceedee as disclosed in the written statement or the response filed by the proceedee, but once these facts have been disclosed in the written statement to the effect that his father is so-and-so, Lordship. These are on rebuttal, Lordship. So, Lordship, last finding in this case. Paragraph 45, Lordship. We are of the view that proceedee has been able to adduce sufficient and cogent oral and documentary evidences in support of his claim that he is an Indian and not a foreigner on the basis of preponderance of probability. The oral and documentary evidences adduced do certainly indicate that the proceedee Abbas Ali Talukdar is in all probability an Indian citizen, which has not been shaken by the state in any manner, nor the state has adduced any evidence to suggest the other alternative view that the proceedee is a foreigner. So, Lordship, my humble submission before your Lordship, the petitioner who have adduced the evidences, Lordship, exhibited the documents and tried to prove his case, Lordship, but there was no rebuttal from the state, Lordship, and the learned tribunal committed wrong, Lordship, discarding those evidences, and lordship merely that the OP said that my father got married in the year 1995, that will not discard 1985 voter list. Even if we lordship discard 1985, his father's names is there, lordship, 1966, 1970. So my humble submission before your lordship, this person may not be suffered any further lordship. He may be declared Indian on the basis of these documents, lordship.
Father's name you said appeared in the voters list of 1966 and 70.
1966, 17, and 1985. Then he died, lordship, 1997, only stepmother and OP, lordship. Jamabandi, lordship, he is having the lands in the district, in the state of Assam, lordship, in 2 plots, lordship. And moreover, lordship, in this case, since,
Can you read the name of the village of this Jamabandi?
yes, lordship. Exhibit 5 in additional affidavit, lordship, page 46.
46.
Yes. Ambari is there, lordship. Original is page 47, lordship. Bongaigaon, Uttar Salmara, Srijangram, lot number 8, Ambari.
What did you say about name in Jamabandi?
Lordship, the name of Basiruddin is there, lordship. Then he was strike out his name, page 49. Pattadar number 1, Basiruddin, Pita Alam Sheikh, lordship. I'm reading from the original, lordship, 14. And petitioner name is Pattadar number 4, Ahmad Ali.
Yes.
Pita Basiruddin Sheikh. Remark column, lordship, 29/5/2017, Tarikhor Namjari number Sensor Hukum Morme, 99 number Dagor Mati, Uttaradhikari Hutre Mohammad Basiruddin Shekhar Stholot, Mohammad Ali Pitri Basiruddin Sheikh, Aru Ahmad Ali Pitri Basiruddin Sheikh, Aru Siddiq Ali Pitri Basiruddin Shekhar Namot Namjari Kora Hoy. And in the exhibit 5, lordship, page 47. Patta number 45, Pattadar number Ahmad Ali, Pita Basiruddin Ali.
Page 47.
Page 47, lordship.
Yes.
Good. Lordship, before arguing, lordship, I want to go through the judgment of Moniruddin, lordship. Once again, lordship. If lordship permits one day time, lordship, I will.
Let's go to next Tuesday.
Lordship.
Thursday we have a
Lord.
Thursday we have a special bench.
Lordship, Tuesday I am not
Whether
available.
the same bench will be available or not, lordship, next week.
টিউজডে মই নাথাকো
Okay, then we have to do it on Thursday.
লৰ্ডশ্বিপ
If your lordship, Thursday, if there is a special bench, can it be on Friday at 2 PM, lordship?
No, we don't know. Because Friday again, many matters have been listed.
Lordship. Can it be at Thursday at 2 PM?
We are not saying the time because we don't know about the
It will remain as part of lordship.
the submissions of.
মই দিয়া নাই মই এইটো উলিয়াই দিম তলত।
The submissions of Mrs. R. Chaudhary and counsel for the petitioner is concluded, comma, reserving right to reply. Next para. All the respondents are represented. Next para, all the opinion made by Mr. G. Sharma and its standing counsel for the FT matters. Comma, list has a parted matter on. 24th, 7/2025.
Deeply appraised, lordship.
আৰু আপোনাৰ
Copy to the. To be for this as well.
এইটো এই কেছত যাব।
অৰ্ডাৰৰ পেজটো দিছে